business I gotta take care of.
Nothing's changed since the last time you made the argument and I denied it.
Nothing at all.
I don't need a response. Motion for bond reduction denied. Thank you.
Thank you, Judge. And on behalf of Mr. Burrows, Mr. Burrows, please state your name for the record.
Deshaun Burrows, can I speak, Your Honor?
Why don't we let the prosecutor put her appearance on?
Have at it.
What do you want to speak?
All right.
Your neglect.
Pardon?
Neglect. You told this man to,
Oh, which man?
this gentleman right here, about my dog last, on 29th, to send him a note at the Humane Society. He never done it.
Sorry, Judge, if I might. We were here about 2 weeks ago, at which time the court said that you will be willing to sign an order for his dog not to be euthanized at the Humane Society.
Correct.
I did send a stipend order to Ms. Hughes on that matter. She asked that I just do a order without a stip. I've emailed that to your court officer, and I have a copy here in my hand for your signature, Your Honor.
A week after the fact. I called him maybe like 5-6 days later to see what's going on with that.
Okay, so, sir,
Yes.
frankly, the dog has nothing to do with your case.
Okay.
Mr. Feaster is not your caretaker.
Understand?
Mr. Feaster didn't have to do anything. I asked if he would do that because that was a concern of yours. He
Understand.
did it, but he can't do it alone. He needed this prosecutor to sign off on it and then to get it over to me. So for you to sit here before this court and say in any way Mr. Feaster has been derelict in anything that he's done, that has never been the way that he has behaved before this court. He did not do so at this point, and quite frankly, you owe your attorney an apology.
I apologize.
Thank you.
No problem.
Thank you, Judge.
Thank you. Now maybe we get down to the business of the case.
Thank you, Judge. In trying to move these matters forward for Mr. Burrows, we could set these matters for preliminary examination, please, Judge.
This is the order that he was derelict in getting to us. Discovery is complete.
That's my understanding, Judge, yes.
Do people have their witnesses available on the 26th? Preliminary examination in this matter will be set in person March 26, 2024, 9 a.m. before me. Okay. Before me. Bond will continue. I have signed the order. You want a copy that you can get over to the Humane Society, Mr. Feaster, as your dereliction in your duties?
Thank you so much.
To everything.
Thank you so much.
You
Judge.
sure?
I will get it over.
You were sure to get it over there?
Yes, Judge.
Okay.
Thank you.
Make sure to get a return receipt so we can show it to him, so we don't have to hear this garbage again.
He's asking me to address his bond, Judge.
Seriously?
Yes, Judge.
Okay, go for it.
Sorry, all three files are scheduled for exam, right?
Yes,
Thank you. That's
they
all.
are all three set on that day. You can.
Thank you very much, Judge, again for signing the order. And just speaking to my client, we set this matter for exam to try to get this matter resolved as swiftly as possible for Mr. Burrows. But he still would like me to address his bond. He's asking that you consider releasing him. I made the same argument when we were here last time. And all the same things I said at that time are still true today. And so based on that, Your Honor, he might consider a personal bond so he can go home, take care of his other dogs, make sure that they're going to be healthy and have all the treatments they need.
But nothing's
Oh, and not
changed.
only the dogs, not that other business I gotta take care of.
Nothing's changed since the last time you made the argument and I denied it.
Nothing at all.
I don't need a response. Motion for.
And just like that, the motion is denied. No hesitation, no extended debate. This is what courtroom efficiency looks like. The judge doesn't need a long explanation because the legal standard hasn't been met. When nothing changes, the ruling doesn't change. This is a powerful example of how quickly decisions can be made when the law is clear. For viewers, it might feel abrupt, but in reality, this is exactly how courts are supposed to function. Focused, direct, and based strictly on facts. It also shows something important. Persistence alone doesn't win in court. Evidence does. So ask yourself, should the judge have given him another chance? Or was this the correct call?
Bond reduction denied. Thank you.
Thank you, Judge.
Thank you, Judge.
You hear me, sir?
Thank you.
Can you hear me?
Yes.
Okay, fantastic. You're welcome.
Go ahead, counsel.
Thank you, Your Honor. Ours is a simple, non-residential eviction case. Mr. Lonsway, the defendant in Mr. Talaski, the defendant in possession, has been leasing the fields at the property 10 years with horses. He's received the notice to quit, which was sent to him December 6th, 2023, informing him to remove his horses and vacate the property by February 1st, and he has not done so. It is a fundamental principle of property law that a fee simple property owner has the right to exclude anyone from their property for any reason or no reason at all. We're not obliged to justify to the defendant or this court the reason for the eviction, but in the interest of fairness and to put it on the record, I'd like to do that.
You're going to give me a lecture on doing for 35 years?
Well, no, I know, sir. You're quite qualified. I know that. This is simply, it has nothing to do with animosity. It's purely a question of liability. Maintaining this property for the keeping of horses has become prohibitively expensive. The fences around the property are rotting and fallen down. Whole sections of the fence are being held up by steel posts wired to the rotting fences. My client intends to just tear down the fences because of their disrepair. The defendant's horses got out on 3 occasions last year, and luckily they stayed on the property, but we fear they will wander into the road or worse. There are other annoyances, but they pale by comparison to the liability and the fence repair cost issues, which my client simply cannot keep up with. The defendant needs to get out immediately and hopefully pay my client for the months that he has overstayed. This is not an eviction for failure to pay, although he has failed to pay. Either way, we need as soon as possible. Thank you.
Okay, it's far hard for me to hear it with him. I'd like to see what he said, but anyway, go ahead. My turn?
Yes.
Okay. I've been doing horses for 50 years in this area. Whitmore Lake, Livingston County, Oakland County, and I was at places 18 years. This place with Mr. Lonsway was 12 years, and this all started in November of 2021 when they had a big cow barn. He has 3 pastures that I rented, and he had a big cow barn that it burned down. It burned down because Mr. Lonsway put a chicken coop inside the barn with a heat lamp, and I was called by neighbors that the barn was burning, and the police, the fire department were out there. It's a long driveway, and they were pumping water, and they finally put the fire out, and so everything of mine was destroyed. Everything that Mr. Lonsway had, tractors, canoes, he had the machinery, new roof, silos were out there, and he, it burned down, and that was not my fault. And Mr. Lonsway approached me and said, the horses can stay here, although they were now in one pasture. And so I accepted that, and I didn't demand him to do anything to me or reimburse me. And so
Sir, let me just ask you, is there a written agreement for the leasing of the land?
yeah, we signed an agreement 2010. Okay, we had a
For how long?
then I don't think it said anything. It was just started to protect Mr. Lonsway because we had a kind of a disagreement with some people about cutting the hay in a hay field. And so he just said, well, we need a lease down there. How much was it? And eventually when $200 a month. And,
Well, I guess what I'm trying to figure out is when did that lease expire?
didn't never expire. Never, there was no limit other than Mr. Longway filed for me to leave, probably, 2003.
Okay, but
Go ahead.
that would have been before the written agreement.
No, that was after the agreement. Yeah.
So when was the written agreement?
Huh?
When was the written agreement? I heard you wrong, maybe.
2010, something like that.
All right, but you said he filed to have you leave in 2003? Or
No,
did you mean
no.
2013?
No, 2023.
23.
Yeah.
Okay, gotcha. Okay.
Well, the problem was, okay, just another thing. So, about 6 months later, he was cleaning up and, he got the idea the horses were getting out after the barn burned down. And we went and fixed the fences up. So they were confined. But 6 or 8 months later, he came up with that the horses were getting out and he was liable, which wasn't true. They never got out before. And he said I had to leave. And so then
Okay, so first of all, help me. How many horses are there?
there were 3 on one side, 1 on the other side.
So a total of 4.
Yeah.
Okay. And do you not have a place to put them? Is
No,
that
well,
the issue?
another problem happened.
Okay.
I got, so, on 1 August of last year, I was bringing hay to the horses, or I went to buy hay. I couldn't buy the square bales, so I looked for some round bales. I found 2 of them. And so I loaded them up and I brought them one was a big one was a small one. I loaded the small one when I got to the farm into one paddock. And I went to unload the big one and I couldn't. It wouldn't move. And I tried everything that I could do, run up the vehicle, run down and see if it would move. It maybe moved a little and sat back. So fine, and I didn't have any ropes, which I usually had because they were all burned up. And so I went up there one more time, tried to push it off, and I got my legs and caught in the hay, and they just, I was kept there I fell off the back of the pickup. My legs stayed in. I laid on the ground. There was nobody there. I started to call for help, but the driveway was 150 yards. So I laid there till 4 in the morning, from 4 o'clock until 4 in the morning. Then the daughter came and she heard me. I don't know if she was with somebody, but I tried to tell him to move the bale, but then I said, call 911. So I ended up in U of M hospital for 8 weeks because my leg was so swollen. U of M and rehab. Finally, I got out in October, 1 October.
Okay, so what does this have to do with you being on the property?
Because I had to do this with this leg, and it's still bad. It's still bad for me.
Okay.
I need somebody to help me, feed the horses with these round bales which gives me time to look for a place and to try to heal. I have an appointment. I had one appointment with VA and she looked at me and said, well, let's wait till to April and we'll look at it again. And I want to find out what's my prognosis, because I can't feed the horses the way I want to give me time. Otherwise, I'd have to be there every day. And I live in Monroe and I have to drive 50 miles. So I'm looking for them for at least 30 days, but maybe 60 days, to see how I'm going to do, keep the horses there, pay my rent. And Mr. Lantway said I could stay, and then he changed his mind based on error, if nothing else. Go ahead.
Okay, but what I'm hearing
Yes.
is that you'll move the horses,
What?
that you'll move the horses.
Eventually, yeah, I have to move the horses.
Well, eventually is probably the problem.
Well, right, yeah. Because I'm in Monroe now. I have been there only a couple of years. I haven't found a place. I had one place lined up. They changed their mind. So, go ahead.
So I get back to my question. How long do you think you need? I'm not
Well,
saying you'll get it, but how long do you need to get the horses?
Well, I have an idea on the 2nd of April, but I would need at least 30 days to stay and have somebody there that will help me. I know he will. And so I can look for some more. I'd rather have 60 days.
No, I know, but just so I'm clear what you're telling me.
Yes.
You're telling me that in 30 days, you could have the horses moved.
If everything goes right, yeah, I could probably do that, but I don't want to be alone at a new place without an assurance that my leg will help me do the chores that I need.
No, I understand that,
Yes.
but the issue isn't that part of it. The issue is that the horses need to be moved.
Yes.
Okay, so what I'm hearing is you're in agreement to that. It's just
Sure.
timing of the move.
Yes.
All right. Counsel, how soon is there any leeway you have regarding when the horses will move? Because I will just say this.
Yes, sir.
If it had to go to a judgment, you had to have the horses removed. And that means you're going to have to call somebody to move the horses, potentially board them. And that's an expense that your client will initially at least incur. So balancing that, is there any leeway in terms of time of the move of the horses?
The defendant's had far longer than the statutory notice. He was on notice of this 9 months ago. We can accommodate 30 days. That's not unreasonable given Mr. Tuleski's situation, or somewhere thereabouts. 60 is probably a little bit too long. I wouldn't like to face my client and tell him that's how long it was, but 30 to 60 would be acceptable. Yes.
I'll pay on the 15th of the month. So I would like to, continue that 15th of the month, 60 days in advance. And that's the way I've been paying. And just to keep the math right, so whatever the date is, it should be the 15th of the month. So today is 15th of the month, but I think after 2 April, and I see the VA, I'll have a better idea, and 15, so. But anyway, that's what I think would be fair. Go ahead.
Okay. if I gave you 30 days from today, and I can't, here's the problem. I feel for you regarding your leg,
Yeah,
but I can't condition the moving of the horses on that. Okay. I can't say, well, once you get better, then that's when it will happen.
Yeah.
I certainly can take that into consideration, but it seems to me that the issue here is that if you had them out by the week of the 15th, gave you that 15th of April, could you do that?
again, I'd have to see what is available on the 2nd.
Okay,
And
but here's going to be the,
what I would be doing,
sir, here's going to be the problem.
yes,
They're going to get a judgment for possession. The question is when will they be able to execute on that judgment to basically forcibly remove the horses from the premises? All right. If they do that, it's going to be a problem for everybody, quite frankly. Whenever we get into these cases, it's a problem all around.
yes.
Don't want to get to that point. So we're going to have to pick a date, and somehow or another, that date is going to have to be the date that happens, unless you guys come to some other thing if something happens.
Yeah.
But that's going to be the date.
This is one of the most important moments in the entire hearing. The judge explains what will happen if the deadline isn't met, and it's not a good outcome. Forced removal, involvement of the sheriff, and even the Humane Society. This is where things go from discussion to real consequences. And notice how the judge is trying to avoid that scenario by encouraging an agreement. This is what many people don't realize. Court isn't always about punishment. Sometimes it's about preventing a worse situation. But at the same time, the judge makes it clear that a deadline will be set, and it will be enforced. So the question becomes, is 30 days fair, or should more time have been given?
Of the court's order.
Well, how about 30 April? 30 April. 30 April would be,
Counsel?
We can accept that provided there's some type of penalty if he doesn't have them out. We can just turn the horses out and what happens to them happens. My client is not in the position of being able to
Well,
of caring for his horses.
Can't do that, because if you can't just let him run. If it gets to that date, he's got to.
Then what surety do we have, Your Honor, that he gets them out on the 30th? If you have a suggestion,
Well,
I'd like to hear it.
The only surety that you have is you'd have to call the sheriff's department to execute on a writ. And then the reality of what happens in these situations is you call the Humane Society comes out, gets the horses. I don't know if they're still doing that, but that will the last time this was done, that takes time because the Humane Society doesn't board the horses themselves. So then they have to find individuals to take the horses, which won't happen overnight.
I'm learning far more about
If you're asking for some guarantee, I can't give you a guarantee except a date where you can then exercise your legal remedies.
Correct.
That's the best that I can do.
okay, I still plan to pay rent. I have money in my pocket. And so, he refused to take my money, so I'm willing to pay.
Okay, so how much are you behind? So that's
Okay, 15 January, 15 February, that's 1 month. February to March is 2 months. I got that in my pocket.
So
then
you would be paid through March 15th. You're saying with what's in your pocket.
yes. That's today. Yeah.
Okay, and how much is rent?
200 a month.
Okay, so you have 400
Yes,
that you can get to the plant.
I could give,
Okay, so now let me ask you this. When could you get the March 15th to April 15th payment made?
anytime. I mean,
Okay,
I was
so
gonna do it yesterday, but
Okay, so
Yeah.
here's what we're gonna do. We're gonna grant them a judgment for possession with the writ date being April 30th, 2024.
Thank you.
You're to pay to the plaintiff the 400 plus an additional 300,
Yes,
which will then be half, I'm taking half of April.
yeah.
So you'll pay the 15 days in April.
that'd be fine.
All right.
I can write him a check. I can write him a check today.
Okay. I'll let you guys handle that because that's really not part of the case, but I'm going to order that be paid. Otherwise, I'll issue a writ sooner. Okay, so you pay through the 30th. You're going to be paying to the plaintiff a total of $700, which is really the
Right,
400
yeah.
that you have
Sure.
the next month and then the 15 days.
Well, I'll pay him when, okay, that's fine. Yes,
Okay?
Yeah.
And then a writ would issue on the 30th. Okay?
thank you.
All right.
Thank you, Your Honor.
I need a judgment. You're welcome.
You have one here that I can fill out?
I don't.
Not you.
Are we good to go?
But I think they might have some up front. At the front counter.
I have a
I'll sign.
blurb here. Would you like to have this?
What's the blurb?
Well, what happened over over the years. I gave
You
him.
want me to read history?
Yeah, it's up to you.
I became a lawyer, so I don't have to do history or math.
Okay.
All right.
That's what I usually tell clients.
All right. And sir, you're a veteran?
Yes, sir.
What branch?
Retired Army.
Army?
Yeah,
Okay.
thank you.
My
Are you?
thank you for your service. No, my dad was in, but thank you for your service.
Thank you.
All right.
Support.
Because I didn't have to serve because of people like you that did. And I'm always mindful of that.
Huh? Oh,
All right.
thank you.
All right.
My
Thanks. That's right.
She wasn't trying to take you in. All right. Take care.
In the end, this hearing covered multiple issues, but the message from the court was consistent throughout: accountability matters. Whether it was correcting a defendant for blaming his attorney, denying a bond request with no new evidence, or resolving a property dispute involving horses, the judge stayed focused on facts, procedure, and fairness. The court showed patience where it was needed, but also drew clear lines when limits were reached. And that's the balance every courtroom aims for: understanding the situation without losing control of the law. If you found this case as intense and eye-opening as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more real